Hello, everyone, and welcome to one more session of Address, which is a real time dispute resolution platform. And as part of this series, today we have with us a renowned panelist, Mr. Krusch Antony. He is based out of Kochi. He's an advocate with more than 25 years' experience, and he's a partner at Kingsteps. And he's got a variety of certifications and experience in arbitration and mediation and resolving several aspects. The topic we chose for today is about the new Stamp Act or the new stamping interpretation provided by the NN Global in the 7 judge bench. So, with that, let's bring in our panelist. Welcome, Mr. Krusch, and thank you for joining us.
Thank
So,
you, Dr. Reddy.
thank you.
Thank you for inviting for this particular session by the arbitral platform Address. And I am very happy to share my views, though limited in my understanding, as to the requirement of stamping in the arbitration agreements. So briefly, I have to cover up the global scenario and the Indian scenario. As we all know,
Let me ask if you don't mind intercept a minute and slow down because I want to introduce some context for our viewers.
okay,
Since you said the word global context, in that scenario, is there such a stamping in other countries also?
yeah, to be frank, requirement of stamping in other countries, I have not examined it in detail, but in general, I would like to uh, touch upon the issue of very requirement of writing of an arbitral agreement. Okay, we know very clearly that many countries, especially civil countries, civil law practicing countries, there is no mandatory requirement as to writing of an arbitral agreement. So when such a context is prevailing in the world, to some part of the world, the very requirement of stamping is absent or it is never visualized because arbitration agreements are construed, which is more free in nature, flexible in nature, in generic. It is not that to be complicated. It has to be engaged by parties either by oral or by exchange of emails or telephonic conversation or communications. So this is enough to prove that the parties have agreed for an arbitration. So when such of informal type of agreements are existing in one part of the world, so that has to be understood and examined by us too. Moreover, the UNCITRAL law, of course, we have almost copied down Section 7 from UNCITRAL, but UNCITRAL law as such is not mandating the requirement of writing the law as such. But further we go to the UNCITRAL rules of arbitration, we can see that Article 1, the requirement of writing is being mentioned. But of course, it's in the rule of one, the adopting the rules is a secondary portion, but the act itself is not compelling. But Indian scenario, it's a compelling situation that we have to be in writing. So the first part of this conversation, I believe this has to be examined. So the moment when it writing is compulsory, only the secondary question of stamping or not stamping comes. So to my best of understanding, a good part of the world is not following the mandatory requirement of writing. So especially civil law countries, to my greater understanding, it may not be writing. That's the number one. Then, if you examine into the corporate or modern practices, we know that many of the communications nowadays, which happens in through exchange of mails. So exchange of mails, if you agree for arbitration, now take for example, if you bring into Indian context, of course, it is in writing now. But this exchange of mail in writing, now how to get it into stamping? That's a practical issues are involved into this. Whether our collector of stamps or adjudicating authorities will agree for this, I don't know. So those are the practical issues which we are going to face in this situation, especially now after the seven bench conclusion of or the findings. So many practical issues are remaining to be addressed. So that this is my first point.
Okay, let's touch a little bit upon that. For example, if there is some email communication between us, which let's say is a contract, or I have received some, I don't want to use the term insurance because usually insurance has a term called consolidated stamp duty paid. But when there is a mass contracts that are done online and we just get a email, for example, a credit card application, that is also an agreement. So how do we stamp those things? And you're talking about a practical situation. One of the things that we practice is we buy a stamp paper because where there is stamping still done on papers, and then we attach it to this particular agreement and write the reference number of the contract and say this is stamped for this purpose. So that is what we do. In other places where there's franking to be done, we still write this context that this particular stamping is for this document, and we get it done. In just in these two aspects, do you see any complications?
Yes, I do see complications because the very stamping in Indian scenario, we know that various methods are there in stamping. Non-judicial stamp papers, then franking. Now there are online mechanisms. So various methods are there. While these methods are prevailing one side, the other side issue, deficiency in stamp duty, that can be often coming because lack of clarity how much stamp to be paid. Moreover, state-wise, this is different. Though we have a central stamp act, we have state amendments, and there is much of a difference in stamp duty paid to be, uh, state-wise. And the authorities involved. The authorities involved here may take different interpretations, whether they can stamp or not. For example, email communication, if I take a printout and go to the collector or adjudicator, I don't think usually they will agree for stamping that because they may have their own reservations. To my understanding, there are even cases wherein which parties have approached directions against the adjudicators of stamp duty to you know take necessary stamping. So there are a lot of litigations running around this. Of course, to my best of understanding, the adjudicator got the power even to uh, fix penalties up to 10 times of uh, what is the actual stamp duty. I think there is a case wherein the Supreme Court has mentioned that the adjudicator need not fine up to maximum like 10 times all the time. He can vary in between. So that this is an area of lot of confusions uh, is coming to my understanding, and unnecessarily there can be delay, and unnecessarily litigations can be prompted uh, in this matter. That's why even in this seven bench decision, it was clarified that at particular time of section 8 or at particular time when we approach under section 11 of arbitration to the concerned high court or supreme court, wherever, you need not go detail into these aspects, whether stamp is there or insufficient or not. This has to be again to be decided by the concerned arbitral tribunal. Of course, that's a welcome part because unnecessarily you should need not litigate on that. Now, it's very clear with the decision that 35 of the Indian Stamp Act, it mandates that it has to be there, stamping has to be there. But now the larger bench has clarified and relied upon, the 42, section 42, wherein which it clearly say that it is curable defect. So it's very clear and it's a welcome step. At least we found out uh, the wisdom saying that it's a curable defect. Okay, that's a welcome part. But to my argument or my thought is, when it comes to precisely arbitration as a subject matter, which is global in dimension. See, unlike the Indian scenario, now arbitration is a global scenario. Now, uh, now if it is an international arbitration agreement, uh, now one of the parties from another country, and one party is an Indian party. In this situation, what will be the discretion? Is there any discretion, or should they go along with the Indian Stamp Act or not? Those issues, I think, are not covered in this particular topic or particular judgment, which needs to be examined to be in the present day context, because globalization is very much happening, and particularly arbitration mostly to be looked upon from a global perspective, following the institutional model law and other things. So even if we have come close to some of the disputes or disagreements and interpretations, whether to be stamped or not, of course now it is to be stamped, of course the defect can be curable, all agreed. But looking from the background globally, with see couple of countries do not want to have a standard form, a standard way of in writing. They can have informal communications, or by clicking into some terms of agreement in a website, you agree for an arbitration. All this is being agreed at one time, where they nobody is expecting that you should follow some of the peculiar or a general act of stamping and duty, all those things, because state wise, region wise, country wise, the stamp duty part will be keep on changing, or it's very local in dynamics from a global perspective.
But
So
let me cut you short here for a second.
okay.
Um, with the Stamp Act, see, people keep referring to the NN Global judgment, especially the first time the five-judge bench came out with the judgment. But even before then, there are a plethora of cases which have interpreted the Stamp Act, and what the seven-bench judge has said now has already been said before. And if it is a
Very,
foreign contract and it is brought into India for the purpose of litigating or enforcement, whatever it may be, then the Stamp Act has a provision where it says within 30 days, if I remember correctly, it has to be stamped once such a contract enters India. So there are workarounds on that, but as you said, everything is not black and white, a lot of interpretation here and there. But coming to arbitration, let me ask you a question. Let's say court has appointed arbitrator and a sole arbitrator enters into reference on January 1st. So he has to complete the pleadings within 6 months as per the section 23 subsection 4. But if the process of stamping is raised and the stamping process takes, let's say, 2 months, what happens to that 6 months pleadings time? Does it automatically get extended by another 2 months? I mean, these are questions which have not been answered, and which, as you rightly said, could lead to more litigation. Of course, there are many more complications in the Arbitration Act, but specifically coming to the stamping part. Now, let's forget that and assume that both the parties choose not to go for stamping. Then what happens? Arbitration can proceed, right?
exactly, that's how the case law says that if arbitrator accept the document without stamping, it is accepted, and it will be continued. That's what the case law says.
But if without stamping, the document cannot be introduced as primary evidence.
Yeah, that anyway now, since the seven bench has concluded uh, the issue as such, so now onwards, uh, all the arbitrators has to be careful that he has to complete the process as to stamping, then only to accept it in evidence. So this is a new trend which comes in between. Earlier, even I am a party to arbitration wherein which stamping didn't happen, and the case laws were discussed, and arbitrator himself was confused as the counsels were taking different positions, wherein which I was a counsel to the dispute, wherein which I didn't have even the original agreement. The agreement was with opposite councils, so opposite parties. So they are not taking and bringing the originals. Then how do I, adjudicate it? So those are the issues which we face. But in that particular case, parties never contended for, uh, or the opposite council also not contended that it has to be stamped. So the arbitrator accepted it. In between, the five-judge judgment came, so the arbitrator got into confusion. So arbitrator passed an interim order stating that you adjudicate and come back. Okay. So by the time when we have only Xerox copies of the agreement, to my best of understanding, this nobody is going to accept the Xerox copy in Indian situation and to adjudicate it, because our authorities are always fixed in their notion or with their understanding. I have to see the original, verify the original. Like that, they may take their own view. Then I am left with no other option. I have to approach the concerned court, probably the high courts, to take a direction for adjudication. So this is the point which the larger vision get into confusion. The larger vision, the larger purpose of stamp back, to my best of understand, is to secure revenue for the state. There is no much ideology involved in it. So, as a citizen of India, a contracting party, I am approaching them. Please stamp on my papers. Now he is fixing another set of rules and regulation. I want to see the original, or only on original I will fix, or I want this agreement to be on a stamp paper. So X, Y, Z new rules are coming. So without this clarity, stamp back got a lot of confusions here and there. And usually the officers who are in charge, they take their own understandings and interpretations, or they may hardly consult their the government council, or if government council also not that sure on what to do. But they are missing one point, the larger vision of stamping. What is there? Any illegality are we committing? No. Stamping is a stamping which they think that the moment it is stamped, it is something which I am trying to make a illegal contract to a legal contract. That's not the idea about stamping, to my understanding. I am just trying to comply the process. There is nothing like I am trying to change the date. I cannot change the date, or I'm trying to bring any falsified documents and certifying it. Stamping is not certifying. So all these areas are quite confused with governmental authority. They themselves think stamping is equal to some sort of certifying, as if I'm doing something. So lot of issues are being created. So we need to have a direction that you freely stamp anything. What is your problem? So that is my viewpoint. Let us be flexible on it without giving a flexibility on these notions or wrong understanding or governmental thought process. Things will not come to an end. And anywhere, any treasury, any place, we know that we can purchase stamp paper. No questions are being raised. Once I forget stamping, certainly after particular time or date when I want to litigate, there comes a plethora of questions and issues. We are not ready to take it as simple as it is. Prima facie, it is being viewed, I have done something very serious wrong. That's why the government itself, the act itself says that you have to penalize. Okay, penalizing, of course, Supreme Court has clearly finally told that you need not penalize maximum depending upon situation and circumstance. We understand that people to comply the stamp laws, so there is a penal provision. But despite keeping a penal provision, why to view a person approaching the adjudicatory authority with lot of suspicion? There is nothing. It's just a matter of stamping. So there has to be proper directions to the concerned authorities. Now, see, adjudication, especially with fine and all, it has to be taken in a simple way. And the real test, whether the genuinity or authenticity or any certification, that is completely different. And those authorities are different. Falsifications, authorities
Okay,
are
Mr.
there.
Krusch, I think you made your point,
Yeah.
but yes, there are definitely a few points of gray area, but probably I would say there's more education to be imparted rather than interpreting.
Yes.
So, of course, when it comes to revenue, every time the government obviously is interested in revenue, but at the same time, that cannot be a reason to deprive a party of its contractual rights. And
Yes.
what happens to limitation while this document is getting stamped? So these are several questions which are there, but unfortunately we have come to the end of time, so we need to close this session. But a lot of interesting points that you raised, some clarifying things, certain things more confusion rather than clarity. But that's how we learn, that's how we improve. So, with that, I would like to thank you and with your consent, conclude this session.
Thank you, Mr. Pradeep Reddy, for inviting and having a nice session, bit of an interactive session. Let us hope that we meet again and take it forward.
Sure.
Thank you.
Thank
Thank
you.
you very much.